Good morning, everyone, and welcome back to our weekly webinar series. This will be our 92nd episode and a very, very important topic with respect to preferential transactions under IBC. Over to Anil, sir.
Thank you, Ankit, and welcome to the regular audience. The subject today, we would immediately come to the subject today, and that is the deliberations on the preferential transactions under IBC under section 43 and 44. We would be dealing with the requirements of the law, relevant reasons, and why the RP is responsible for doing all this, and then the landmark judgments on section 43. So in fact, there are various issues. The issues are regarding the look-back period. Then there are issues regarding whether the intent of the transaction is important or not. Whether the normal or regular course of business, how do we define the normal course of business? If the transaction has happened in the normal course of business, how do we define that? So understanding the background of the preferential transactions, we actually found that in earlier winding up proceedings, the name of such transactions were basically fraudulent preference, and that was covered under section 531 of the Companies Act. And later on, when this Companies Act 2013 came, so the relevant and modified section was section 328 and 329. No, so that is the background, and in any case, when this particular code was notified, this section 43 and 45 was also notified. So we see, like, when we see the why the RP or the liquidator is having that obligation. One, that the RP has a duty under section 25, subsection 2 and clause J of the IBC to file application for avoidance of transactions in accordance with chapter 3 of the IBC. So there are regulations also. In the regulations 35 capital A, the RP is supposed to form an opinion on 75th day. Then on 115th day, such transactions are supposed to be informed to IBBI, and then the application has to be filed within 135 days of the commencement of CIRP. So these are the responsibilities of the RP, and also RP is also supposed to present all the resolution plans. RP is supposed to present all the resolution plans along with the transactions which are observed, found, and determined under section 43, 45, 49, 50, 66. So that is the responsibility of the RP, and RP is also supposed to, I believe, provide all this detail in the compliance certificate, which is in form H, which is supposed to be given by the RP. So when these are the responsibilities of the RP, and also the liquidator has the similar responsibilities under section 35, subsection 1 and clause L. And the responsibility is like to investigate into the financial affairs of the corporate debtor to determine undervalued or preferential, etc. transactions. Also, it is mentioned in the definition of liquidation estate, which is provided under section 36, subsection 3 and clause F, that any value recovered out of proceedings for avoidable transactions would be part of the liquidation estate. So who can file the application before the adjudicating authority? It is either the resolution professional or the liquidator. So the application would be filed under section 43, subsection 1. Now, let us understand what is the look-back period for these transactions. So if the transactions are with the related party, the related parties are defined in section 3, subsection 25. That is where this 2 years period is defined as look back period, starting from the date of commencement of CIR. So if it is unrelated party, then the look back period is 1 year. So the application can be filed either by RP or the liquidator, and then the application can be filed under section 43(1). Primarily, let us understand what is the kind of preferential transactions. So the transaction should be either transfer of a property, or it should be transfer of an interest of the corporate debt. So only these two kind of transactions, nothing else. So what we need to do is that we have to see that within the last 2 years, what are the total transactions where the corporate debtor has transferred any property to any other person, or transferred any interest of the corporate debtor, any right of the corporate debtor, any kind of beneficial interest of the corporate debtor to any third party. May that be a related party or unrelated party. Then we go to section 3, subsection 27 to see the definition of property. And the definition includes money. That means all payments made to third parties. Second, goods. When I say goods, that means that if I have stock and I transfer it to my creditors, that also will become transfer of property. 3, actionable claims. So if I have a claim to recover some amount from someone and I transfer that claim, I assign that claim to a third party, that is also a transfer of property. If I transfer a land or any description of property, if I transfer land, property, building, machinery, anything that I transfer to a third party, that is a transfer where we actually have to find whether it is a preferential transaction or not. So first of all, there has to be a transfer. In case there is no transfer, the transfer of property, transfer of money, transfer of goods, transfer of actionable claims, any right, in case the company transfers it to a third party, then only the investigation begins. So if there is no transfer, then no investigation can be started. Investigation means that the further steps would not be started. So if there is no transfer, then further steps would not be required under section 43 of IBC. So when I say this is the first threshold that we have to cross, threshold of transfer of property or transfer of any interest to a third party, whether it is situated in India or outside India. And whatever is the interest in any kind of rights, any kind of intellectual property, although it is not defined, the definition of interest is not defined, but generally what we can consider about interest is any kind of ownership rights, claim rights, or any security interest rights, all that can be considered as interest. Transfer of property, transfer of interest, this is what is the first step. Then we have to see the category of the third party where this is transferred. If the transaction has been entered into, if the transfer has taken, if the transfer has actually been to a creditor of the company, a surety of the company, or a guarantor of the company. If the money has been transferred to any person who is not a creditor or who has not stood as a surety for any kind of benefit of the corporate debtor, or if the person has not been a guarantor, then the further process stops. Because if the money or interest has been transferred to, if the property or the interest has been transferred to any person who is not a creditor of the company, then section 43 is not applicable. So if any property has been transferred to a person who actually is a not a creditor, not a surety, not a grantor, then the no further steps under section 43 is required. So that means the process of determination stops. Then comes the payment to these parties who are creditors that should have been on account of an antecedent financial debt. Now, even if a person is a supplier to me, even if a person is a regular creditor to me, but in case I transfer some property to that creditor, it should be against that outstanding amount. So if there is no outstanding amount, even if that person is a regular creditor of the company, but if there is no outstanding amount, even then section 43 is not applicable. It should be an operational debt or it should be any other debt liability, but it must be a liability. It cannot be considered, it cannot be said that this liability is restricted to operational creditors. It can be to unsecured financial creditor. The property can be transferred to a secured creditor, unsecured financial creditor, unsecured operational creditor, secured operational creditor. Any kind of liability must be paid by transfer of property. If the person who has been given a property of the company is not a creditor, irrespective of the operational creditor, financial creditor, other creditor, irrespective, that person must be a creditor, then only section 43 is applicable. So therefore, three basically thresholds. One threshold is that there should be a transfer of property or interest of the company. I have defined property. The second step is that the transfer must have gone to a creditor or a surety or a grantor. Third threshold is that it must have gone against a liability. So 1, 2, 3 thresholds. In case we cross 3 thresholds, then we can say, yes, this is a transaction of a preferential nature. This is a transaction under section 43. Now, then again, we have to, the fourth step. Once we have these 3 steps, then the fourth step is the key of this section. The fourth step is that the person who has been given the property of the company, that person will be benefited. That person will be benefited as against his standing under section 53. As against his standing under section 53. So in case the company has given an amount to an operational creditor, while there are other creditors who have a better standing under section 53, then it becomes a preferential transaction. If the money has been given to a secured financial creditor, then it may not be a preferential transaction. The preferential transaction, paying to one and not paying to the other, is also a preferential transaction. If I have 5 secured financial creditors, if I pay only to one, that also will be considered as a preferential transaction. Unless, so therefore we have seen 1, 2, 3 threshold we have seen. Now the fourth threshold is very important, that the preferential transaction is only valid under section 43 when it actually gives a benefit to that person, to that beneficial creditor, to that transferee, the benefit of a situation as compared to his situation under section 53. In case I give a property to unsecured financial creditor, whereas I have secured financial creditors as a liability in my books of account, it is a preferential transaction. However, if I give it to all the secured financial creditors, then it is not a preferential transaction. So when we file an application, we normally consider them as a beneficial creditor. This becomes a beneficial creditor. Now, then when the application is filed, when the application is filed. So we have to see, like, again, I can bring back the scenario, like what are the normal kinds of transactions? At this moment, I actually will say what are the normal common preferential transactions. So I can say payment to unsecured family loans during the lookback period while the debt of the secured creditors is outstanding. Payment of old operational creditors. Why I am saying old operational creditors? Because in case the companies are in going concern and the operations are regularly going on, and I'm purchasing and making payment to the operational creditors only to keep the company as a going concern and with the motive of profit. It has been held in various judgments that the regular business transactions would mean that the transactions are conducted for profit, for meeting the objective of the company, that is profit or goodwill or credibility. But that is the regular business. The old operational creditors who are actually not being paid regularly, they are not supplying to the company, but in case they are being paid, while the debt of the secured creditor is still outstanding, that is also preferential. Payment to unsecured financial creditor, maybe even a prefixed loan installments, maybe prefixed loan installments, where because see there are other NPA accounts, and if I make payment to one car loan, I have NPA account which are secured creditors, and I have another car loan and I keep paying that car loan. I have other loan which are secured creditors, and on the other hand, there is another loan which is a loan against the personal property of the directors, and I keep paying that loan, and I don't pay the other loans. That is also a preferential transaction. Payment to workman and employee during the regular course of business is not a preferential transaction. Payment of any tax against the order of any authority would not be a preferential transaction, because that's a tax that I have to pay because there is an order. Payment of a regular taxes like indirect or direct taxes, that would not be a preferential transaction, even if some past liability is paid, even if a old liability of the tax is paid. That's a regular business of the company. It has to be paid. So that is also not considered to be a preferential transaction. So as I said, that normally those creditors are also paid who have taken post-dated checks from the promoters. Only to avoid litigation, those creditors are also paid. However, the others are not paid. So this is also a preferential transaction. I believe some tax dues, some old tax dues, where there is an existing risk of prosecution of the promoters without any order of the court, if those are paid, to my understanding, that is also a preferential transaction. Regular taxes are not, but old taxes, and the company is not likely to go into insolvency. So those taxes are paid because there is a prosecution which is likely to happen on the management of the company. That is also a preferential transaction. Now, if I adjust the receivables with payables, if I assign my debtors to creditors, that is also the transfer of property, and that also would be considered as preferential transaction if that person stands in a lower preference under Section 53. Allotment of flat, allotment of property by a real estate agent against the supply of steel, that also will actually upgrade the creditor from an operational creditor to an allottee. That is also a preferential transaction. So these are various kinds of preferential transactions which I can actually say. So, Ankit, so like, I believe if there is any question on the nature of the preferential transactions, so we have defined clearly what is a preferential transaction. So we are not touching today the undervalued transfers. transactions. We are not even touching undervalued transactions with fraudulent intent. And we are also not deliberating today Section 66 fraudulent transactions. Those we will cover in the subsequent webinars. So today's webinar is restricted to only Section 43, and we have defined the transaction, what is a preferential transaction, and if there are questions, then we can take up. And after that, we will also deliberate what kind of orders are expected, and also what is the kind of jurisprudence on this Section 43 so far. Yes, Ankit.
So there was a raised hand which has now disappeared. So with respect to the questions, we only have one question, which is only talking about that the petition was filed with NCLT, but it was admitted after 2.5 years. So that this question, I think, is talking, Mr. Maheshwari is talking about a very, very perpetual issue, that in case the NCLT, the application for admitting CIRP was filed and later it was admitted late. So the act continues to, of course, read that the look back period starts from the CIRP initiation date. It
Yes.
still does not say that, yes, if a petition was pending with NCLT, then, and we have discussed this at many junctures with IBBA itself. And the whole thought process here is that the idea is to cure the problem with respect to delay in admittance rather than, work on changing this definition, because then it becomes a Pandora's box where you don't know if an application has been filed and it has been settled, and, various things can happen in that case. We also have a question from Mr. Hari Prasad. He's asking that he is seeking more explanation on the post-dated checks as a preferential transaction, and he also says that how do we identify them? So that's something.
I'm not saying that giving a post-dated checks is a preferential transaction. I'm saying there are 10 creditors that I have, and I have given post-dated creditors to one, and I have not given post-dated credit checks to others. And one thing that I'm saying that first of all, it should not be a transaction in the normal course of business. It should not be a person who is regularly supplying goods to the company and regularly getting payment. It should be a person who actually is an old creditor, whereas while the others are also old creditors. So in case this person is paid, it is the intent of the promoters would be to pay this person because he has checks and he will litigate and prosecute the signatories. So therefore, this becomes a preferential transaction.
Sharing a practical experience that you would normally see that promoters are paying the checks that have been given to as post-dated checks to avoid the 138 section 138 under negotiable act liability. So even if somebody can find out older cases which were maybe settled or closed with respect to check bounce cases, there again there might be some preferential payments which would also of course appear in the books of accounts as well. We can go to Mr. Mehraj Kumar's question. He says that what if in pursuance in a court order under CIRP settlement amount is paid and later on CD does go into CIRP? Whether such payment would also be considered as preferential transaction if it has been paid under the order of a court.
Sorry, you can actually repeat this question.
He's saying that in case there is a court order
and
the court order says that you pay this person and settle this amount, and the settlement amount, he's talking about court order under CIRP settlement amount. And if that is paid,
CIRP settlement amount, in fact, this particular issue was also started in the case of Anil Ambani's case with Ericsson, and we haven't seen any outcome of that case. But then I understand that the court order, this is not considered a court order. If somebody file an arbitration dispute, somebody goes to insolvency and the company settles that. If a company settles that, first of all, it has to be seen by settling this particular dispute. Is it something which is the objective is the profit of the company? I believe like when I'm settling a dispute to avoid insolvency, to circumvent insolvency. I think the objective is to continue the company and to keep it as a going concern. That would not be a preferential transaction. However, if a kind of connivance arbitration proceedings with connivance, that can be held as a preferential transaction. However, saving the company from insolvency, that would be with the motive of continuing the company as a going concern, and also the objective of this transaction would be to make profit. Therefore, this would not be a preferential transaction.
Right. So then we talk about Mr. Jain asking that in the transactions which are adjusted by debtors through creditors, where is the involvement of money? It was the observation by bench in one of the petitions under section 43 that money is not involved if the adjustment is happening.
So when we say money is not involved, so I think somebody, some senior lawyer has to present this case in such a manner that, as I said very clearly, that the definition of, see, what is the word written in this section 43? Transfer of property. When I go to the definition of property, it is available in section 3, subsection 27. Then when I see the definition of property, it says money, it says goods, it says actionable claims, it says land, it says any description of property. Now, when it says actionable claim, if I have to recover some money from a person A, that is my actionable claim. So I have transferred my actionable claim to a creditor, to a antecedent creditor, and that has put him in a beneficial condition. That is a preferential transaction. This is very clearly defined under section 3, subsection 27, the definition of property. The money is only one word in the definition. The second word is goods, the third word is actionable claim, fourth word is land, fifth word is every description of property. So it can be intellectual property rights. If I transfer my brand to someone, that is also a kind of or property, transfer of property. So therefore, it is very clear that we are assigning a debt, we are assigning an actionable claim to a creditor. It's a preferential transaction. Of course, we have to see the other conditions, putting him to a beneficial position and itself.
So next question is from Mr. Swami Motappa, and he says if money returned paid as security deposit because agreement could not be made because government agencies did not agree, is it a preferential transaction? So you're saying that money returned paid as security deposit. So basically, somebody
who
paid
has
us.
paid? Who
Yeah,
has
that's the
paid?
question.
So
In case we
the
talk about a government agency, now the security deposit, if in case we are saying that the security deposit has been given back to somebody in preference to other creditors, then that security deposit, where has it come from? I
The
think
question is not clear, Ankit. What probably I understand that the corporate debtor has taken a security deposit and
and
then
yes,
returned.
and that security deposit was taken under some agreement, and that agreement could not be executed because some government agency, and then that security deposit has been paid back.
That
So
has
the
been paid back.
yeah, so the security deposit is a liability, but at the same time, the security deposit is something which was, which we, I don't think it is a preferential transaction because the security deposit.
It becomes a normal course of business, because see, it's a normal course of business unless the transaction is very old.
Right.
If it is a very normal within the timeline, so it's a normal course of business. I have to pay back some amount which I've taken, and that's a security deposit that I have taken. But then it's a normal course of business, because when I take a security deposit, that person becomes a creditor. If I transfer any property of the company, that also, these two things qualify section 43, but it becomes a normal course of business if it is within the timeline of the agreement. If it is an old agreement, it was pending for some time, and then the company is going to insolvency, and then that is being paid, that will be considered as preferential transaction.
Then we have a question that is there any time limit to file applications for puff audit during the liquidation period? I think there is a time, there is a indicated timeline for CARP Liquidation, not sure if there is any timeline for filing the avoidance applications for the liquidator.
No, the primarily the application should be filed by the RP. The time limit is given as 75 days, 115 days, and 135 days as per Regulation 35 capital A of the CIRP regulation. However,
Right.
the liquidator can also file the application in case the RP has failed to do this. Liquidator can also file this application. There are many cases where the liquidator files these applications. So, as far as the time limit is concerned, this Regulation 35A has been held as directory and not mandatory. It has been held by NCLAT. I will come to those judgment that in case there is a delay in filing, still the respondents cannot take this plea that the application has been filed beyond the time limit provided in Regulation 35 capital A. Therefore, this particular petition may be rejected. That kind of argument cannot be placed. So the NCLAT said that this is Regulation 35A and the timelines given in that regulation is directory. It is not mandatory. So it will not make the application as invalid or liable to be rejected. Yes, Ankit.
Then we are talking about employees' contribution quantified EPFO, not in books, account on some prior to CARP, and its relevant period of 2 years can be preferential transaction. Employees' contribution towards EPFO prior to CARP being paid later is very difficult, right? I think employees are again in the course of business. In case you're paying anything to the EPFO or the employees due before CARP, one can say that this is in course of business.
First of all, as per the judgments of Honorable Supreme Court, the Provident Fund is not even appearing in the waterfall arrangement of Section 53. The payment of Provident Fund or payment of gratuity is considered to be outside the waterfall arrangement under Section 53 because it is considered that it has to be paid. It has to be paid. This is what the Supreme Court has held. So if something is not featuring in Section 53, that particular payment can never be considered as a preferential payment.
Right. So I think we can move on to the case laws. There are other questions, but maybe we can answer them later.
So we also have to see when the application is submitted, what kind of orders can be sought from the adjudicating authority. Now, in case we see the orders can be like whatever the property has been transferred, that should be vested that to the corporate debtor. That can be a very, very normal order. So in case that property has been sold by the third party, then the proceeds of that sale of the property should actually be vested back to the corporate debtor, and that money should be transferred to the corporate debtor. Suppose in case some receivables are assigned to a creditor and that receivables are paid to the creditor, then in that case, whatever money has been collected by the creditor from that debtor, that will be transferred to the corporate debtor, which will form part of the liquidation estate, or which will form part of the corporate debtor will own that money. Then in case any security interest is created in favor of a creditor. A security interest is created in favor of a creditor. That means that we have shifted that creditor from unsecured to secured, or we have improved his security interest. He was having a security value of 25%. So we improved the security value of 25% to 75%. That is also a preferential transaction. So that kind of transaction, the order can be that particular security interest which is created should be released or should be discharged. The court can also pay to any other person that this money is required to be paid back to the liquidator or to the RP or to the corporate debtor. That kind of orders will be passed by the adjudicating authority. Now, in case a person is a grunter, and that grunter is he has been paid some amount. So that also, that grunter will be asked to pay back that money to the company. Similarly for surety. So these are the kind of orders that we actually can which we can take. So when we say this, let us try to find out what are the kind of transactions which are not considered as preferential transactions. One, that any transfer of property made in ordinary course of business or financial affairs of the corporate debtor or the transferee. Now, or in the case of Anuj Jain, this particular word, corporate debtor or the transferee, has been considered as and normal course of business or financial affairs of the corporate debtor or the transferee. So both these or has been considered as and. So now we can read it as ordinary course of business and financial affairs of the corporate debtor and the transferee. So it should be a normal course of business and financial affairs. It should be same. It should be normal course of business and financial affairs for the corporate debtor and the transferee. So this is what is a normal course of business transaction. Then any transfer creating a security interest in property acquired by the corporate debtor to the extent that a new value is created. Now, in case a kind of security interest is given to a particular lender, and some again the new credit has been taken, so that also would not be considered as a preferential transaction. So in case the transfer is made in pursuance of the order of a court, shall not preclude such transfer to be deemed as giving of a preference by the corporate debtor. So as I said, it should not be a sham arbitration transaction. It should not be a sham arbitration order. In case it's a sham arbitration order, it can be concluded that this is a sham. Otherwise, any court order taken in the ordinary course of business or given by the court in the ordinary course of business, if that money is paid, then it will not be considered as preferential transaction. However, the question that was being asked by one querist, that was that in case, for the sake of avoiding the insolvency of a company, amount is being paid. According to my understanding, that also would be considered as ordinary course of business. So then we can even see the kind of judgments. So the first most important judgment was in this case of Anuj Jain. It was from Honorable Supreme Court. Anuj Jain, IRP for the JP Infratech versus Axis Bank Limited. This judgment was given on 26th February 2020. In this particular judgment, in fact, regarding Section 43, Honorable Supreme Court actually had defined a process that the RPs or the liquidators should do this process. So the first Supreme Court said that the entire transactions should be seen, should be subject to verifications, and those transactions which are made in 2 years, those should be seen by the liquidator or the RP. That is the first step. And the second step is to find out the person with whom this transaction has taken place, whether that person is a related party or unrelated party. So the first step is segregate the transactions within 2 years. Then define the persons as a related party and unrelated party. Now the third step would be to keep the transactions with the related party up to 2 years and keep the transactions with unrelated party for 1 year. And then see that the beneficiary is an antecedent creditor of the company or not, or the beneficiary is a surety or a guarantee or not. This is the next step. Now, once we have seen the related party, unrelated party, look back period, then we will see whether the beneficiary is an antecedent creditor or not. In case the beneficiary is not an antecedent creditor or a surety or a guarantor, then those transactions should be dropped. And then we have to see whether this transaction would be then we would say we have seen that the transaction would be impacting the situation or a status of that particular person under Section 53, the priority under Section 53, and that should actually be lifted up, or that should actually be considered as even preference within the same priority. If out of the 5 secured creditor, only 1 is paid, that is also a preferential transaction. So this is something which is defined in this Anuj Jain judgment in February 20. It is also very clearly said in this judgment that the separate applications should be filed for preferential transaction, undervalued transactions, and fraudulent transactions. Why? Because see, the Honorable Court said that the examinations of these transactions are totally different. It is said that there is a different degree of examination for undervalued transaction and fraudulent transactions. It is also very clearly said that for a transaction under Section 43, we may not see the intent of such transaction. Whereas for this purpose of Section 45 and 66, we have to see the intent of the transaction. Therefore, the kind of severity, the kind of depth which is required, that is totally different. The depth of investigation is totally different. In Section 43, we have to simply see whether it's an ordinary course of business or not. Whereas in the case of Section 45 and 66 and 49, we also have to see the intent of the transaction, intent of the undervalued transaction, whether it was to defraud the creditors or not. That is something which is Section 49 says. So therefore, the adjudicating authority should also see it differently, examine it differently, and the different orders should be passed. That's what is mentioned in this agreement in February 2020 by the Honorable Supreme Court. So in this same judgment, the ordinary course of business was also kind of explained. As I said, ordinary course of business or financial affair. So this or is considered to be and. So that means ordinary course of business and financial affair of the corporate debtor or the transferee. So this is also and. So this is corporate debtor and the transferee. So it should be ordinary course of business and financial affair for the corporate debtor and the transferee, both. So the focus is basically when we consider the ordinary course of business, the trajectory of the transaction has to be seen. The core question is that what is the normal course of business, and whether this particular transaction is entered only with the objective of making profit or saving the company. So if not, then it is not a ordinary course of business. But primarily, it is the undistinguished common flow of business and not arising out of any special or particular situation. So I have been saying again and again, if there is a special situation, it is not ordinary course of business. But if it is undistinguished common flow of business, then it is an ordinary course of business. So this is where this honorable judgment, Honorable Supreme Court has held in this Anuj Jain. Then we also had a judgment in the case of KL Jute Products Private Limited versus Tirupati Jute Industries Limited. It was again a judgment in February 20. ANCLAT in this case has said that the aim of Section 43 of the code is to protect the interest and undue preference was given in favor of other creditors, and transactions can be called as preferential ones entered into by a corporate debtor. So that's basically undue preference at a relevant time to any person. Then it is also saying that the intent of fraud is not seen. Intent in transaction 43 is not seen. It is simple transaction, and the other part is that the transferee is moved to a better situation. Transferee is beneficial under section 53 position. So this is again the important judgment. Now, in this case, in the case of Vittal S.A. Abhishek Nagori, the liquidator versus Asian Natural Resources India, again, NCLT Indore said that for section 49, there is no look-back period. However, for section 43, there is a look-back period. So that look-back period is important for section 43, and it is no look-back period for section 49 and 66. However, there is a look-back period for section 43, and we have to see the look-back period, and that again from the date of commencement of the CIRP. So in the case of, this was a case of Monnet Ispat. So in this case, two related parties, the refund of loan along with the interest of 18%, it was given. So again, it was said that this payment is a preferential, and they were asked to give back this money. Again, in December 22, the judgment of Thomas George versus 𝐝𝐤𝐬𝐬𝐜𝐿𝐬, the resolution professional of Manufacturers and Traders Private Limited. Again, this is a AAA case. Mr. 𝐝𝐤𝐬𝐬𝐿𝐬 is a designated partner of AAA Insolvency, and this was on the look-back period. And the respondent, in fact, argued before the Honorable NCLT Chennai that the law of limitation of 3 years should be applicable to section 66. Whereas NCLAT Chennai bench said that the limitation of 3 years is not at all relevant. Section 66 is not having any look-back period, so there is no limitation act which is applicable to the section 66 findings. Then again, in the case of Jagdish Kumar Parulkar, the resolution professional of Tile Foods Private Limited versus Vinod Agarwal, this is a judgment of principal bench NCLAT New Delhi, and it again says, and this is the judgment which is in February 2023, the respondents were arguing that the applications were filed much beyond the timelines given in regulation 35A. So the principal bench NCLAT said that the timelines given in regulation 35A are directory and not mandatory. Applications shall not be rejected merely on the ground of delay, but shall be viewed based on the facts of each case. Again, it was said that the filing of application for avoidance transaction and adjudication of the same can survive CIRP. Like this, the CIRP can, CIRP actually, even the CIRP has finished. Even if the case, the case has been resolved, still the RP or these application will survive. Even if the company has been resolved, still this application will survive. So the time limit or look-back period mentioned in section 46 are applicable only to the transactions covered under section 43 and 45, but it is not applicable to section 49 and 66. Again, it was said in this case. So again, in the case of Mrs. Deepti Mehta, the resolution professional of Prague Distillery Private Limited versus Shivani Amit Dhanukar, it is again a concern of whether the transaction was made within the look-back period. But in this particular case, it was found that it was a running account, and the payment was made to a running account, and therefore it is not possible for us to see which payment falls within the look-back period and which payment falls beyond the look-back period. So the liberal approach was given, and it was considered that this is in the ordinary course of business. However, it is also saying that the transaction that falls into place as part of the undistinguished common flow business, that will be undistinguished common flow business. That is what is ordinary course of business. So therefore, ordinary course of business is something which is a matter of adjudication, and it cannot be considered as something which is automatic. So we also have a judgment from unclaimed judgment in the case of GVR Consulting Services Private Limited versus Pooja Bari, and this is an unclaimed judgment. And this judgment was in fact upheld by the Supreme Court of India, and this upheld order was in July 23. So this is the latest judgment, and this was upheld by as the Justice Chandrachud. So in this case also, the dominant motive has to be seen. So the basic issue in this case was the dominant motive of the company in a transaction while deciding the question that the transaction being preferential or not, that is not important. What is important is that there is a transaction, and that transaction has actually put another person in a beneficial condition, and that transaction is not in the ordinary course of business, and that transaction is within the look-back period, and that transaction has happened with a creditor, and then the transaction is for a transfer of a property or an interest. So the intent or motive is not important. This is what was held in this case. So the intent of the corporate debtor is not relevant, since Section 43 envisages statutory fiction, as has been noted above. Whether the act is voluntary or has or not has no relevance while coming to the conclusion whether the transaction is a preferential or not. It was also observed that the even in mortgage transaction for the benefit of related party falls in the ambit of preferential transaction. So it was mentioned in this judgment that the legislative scheme must be kept in consideration while naming a transaction as a preferential transaction. The only escape is that if it is an ordinary course of business, but there is no other escape from Section 43. First of all, the 5 conditions. Condition number 1, it should be a transfer of property or an interest. Number 2, it should be under the definition of property. Number 3, it should be transferred to a creditor of the company or a surety or a grantor. Then it should actually give the benefit of upgrading his position as per Section 53 or within the same category of people. And then finally, it is not the ordinary course of business. Look-back period is applicable. See, when this Venus Recruiter Private Limited versus Union of India judgment came from Delhi High Court, it was in fact considered in that judgment whether Section 43 applications can be proceeded by a person who is no more as RP. So then this court said, the Delhi High Court said that the RP cannot wear the hat of a former RP. So this particular judgment, we actually have to see whether the applicant is RP or not. So in this case, the applicant was RP. However, when the resolution plan was approved, it was implemented. So the RP demitted his office. So when this application came for hearing, the RP was not RP. So therefore, the Delhi High Court said that the RP cannot wear the hat of a former RP. However, this particular judgment of Delhi High Court was subsequently, it was in fact reversed by a larger bench. And the larger bench judgment, which was in fact given by Justice Satish Chandra Sharma and Justice Subramaniam Prasad, in this judgment, it was said that the Venus Recruiter judgment given by a single judge is not correct. So therefore, the RP can continue to proceed against the all these transactions, can continue to represent in these transactions, even if the resolution plan has been approved and it has been implemented, even if he is no more a RP, but still he actually can continue on these applications. So this is what is, Ankit, from our side. And let us speak in case there are questions.
So the questions are the interesting question that if there is a donation by CD to a related party and an unrelated party under, so will it be under puff transaction? So I think yes, a
No,
donation.
donation means that there is a transfer of property, but there is the money is not transferred to a antecedent creditor. If it is not a creditor, then it is not covered under Section 43. If there is a donation by the company to any other person with the intent of keeping the money away from the company, keeping the money away from the creditor, that actually will go under Section 45 and not under Section 43. Very clear, because for Section 43, the payment must have been made to a creditor.
Right. So then, of course, there is an observation that in 2022, the due date for filing the puff application with AA was changed to 130 days. So that's something that we should
Yeah, I
say
think out of 135, there's 130 days now.
is now. And we have we have the query with respect to the EPFO. So I think here he says the company is closed down in 2010-11 and the employee's contribution quantified by EFO much prior to CARP and not in books of accounts and also beyond relevant period as per section 53B1. Will it come under preference? So EPFO and PF dues, there are judgments which put them on a priority, which is of course changing the waterfall mechanism under section 53. I think this question is more to do with that problem.
I have already answered that the provident fund dues and the gratuity, these are not even figuring in Section 53 waterfall arrangement. It is outside Section 53, so that actually has a top priority. So that money is not supposed to be considered as even the funds of the company.
Yes.
This money is considered to be the funds of the provident fund department and the gratuity to the workman and employee. So this is on PF and the gratuity. Section 43 is not applicable.
We have a raised hand. I can ask Suresh Kananji, our partner, to. I'm asking him to talk, and then maybe he can put up his question. You can unmute yourself, Sureshji, and ask your question.
Good morning, Anilji.
Good morning.
This is for section 43. You mentioned that the payment of interest and repayment to promoter during this look-back period fall under section 43. So there is a scenario that during the look-back period, the promoter has brought in, say, 1 crore of money to the company to maintain the company because there's a deficit. So to maintain the company, the promoter has brought in 1 crore of money. And during the same period, some 20 lakhs has been repaid to the promoter. So whether that 20 lakhs repaid is fall under 43.
So my understanding is that there are two separate decisions. One decision is to take a loan from someone, and the second decision is to make any payment of to other person. Taking a loan from someone is a financial decision, and it is an agreement, and that loan, taking a loan makes him a creditor. Now, when it comes to the repayment, the second situation is that the company has some funds within the look-back period, and there is a situation that the company can repay those loans to someone. Now, then in that case, in case it is paid to the promoters, that means the secured financial creditors are still waiting, and the promoters are in fact put in a beneficial condition. When the money is available with the company, it should be paid to the creditors as per Section 53 priority, and not as per the will of the management. This is what the Section 43 says, irrespective of the scenario that the money was brought in by him. No, there can be another scenario that the money is brought in by the promoter along with the consent of the creditors that the money will be paid back and there will be an agreement to that extent. Then it may be considered as a normal and ordinary course of business. But this, I don't think this will be considered as an ordinary course of business because the money was brought in, that was a separate decision. When the money was available with the company and it is being paid to the creditor, that cannot be preferential. That cannot be at that time. No preference can be given to any other person. It should be as per section 53. So it is very clear to my understanding that the money was brought in within the look back period also. That cannot be the reason to say that it is an ordinary course of business. Yes, sir.
Okay.
We have a question from Mr. Ranjanji. Maybe I've allowed you to speak, Ranjanji. You can unmute and say your question.
Yes, actually, that you have told that there is one recent judgment of Supreme Court regarding PF and gratuity dues. So, although it is not very much relevant to today's topic, but what is the
So I think I did something accidentally, which Ranjanji, you'll have to unmute yourself again. I'm so sorry.
hello? Actually, what is the date of the judgment of Supreme Court that you have told that PF and gratuity due would be kept aside from this liquidation estate? So, what would be the fate of those companies which has been dissolved before that?
Dissolved before that? Any company which is dissolved before that, I mean, I think nothing can happen now. So we are only talking about the judgment which has been given by Honorable Supreme Court in June 23. It was in the case of Moser Bears versus State Bank of India, and within the same judgment, the Honorable Supreme Court has also quashed the NCL80 judgment in the name of Sawan Godiwala, the liquidator of Lanco Infratech versus Apala Siva. So the NCLAT judgment which said that it is not the duty of the liquidator to induct funds into the provident fund and the gratuity fund, that was quashed, and the earlier judgment of NCL80 in the case of Moser Bears Karamchari Samati versus State Bank of India was upheld by Honorable Supreme Court. That was in June 23. So it is any company which has already been dissolved. I don't think it is applicable to that company. It is applicable to those companies where the distribution is happening now.
Right. So we are way above time. So I believe we should now wind up and close the discussion for today. And yes, I think we have taken care of. We have another raised hand.
I think the time is already up.
Time is already up, so we can take it up
these
later.
questions separately.
Maybe offline.
Thank you very much, the participants, and we will come back again on the next Saturday at 11 a.m. Thank you.
Thank you, everyone.
Thank you.